Hello students, I am Radhika and I work as a legal researcher with an NGO on gender and human rights. Today, as part of our module on human rights development and democracy, we will deliberate upon development, climate change, and discuss differing frameworks for attaching responsibility on human and ecological sustainability. As we know, climate change and global warming have been called as the greatest and the most urgent environmental problem of our time. It's a problem that has been caused largely by industrialization in industrialized nations in a handful of Western developed states. But the impact of climate change and global warming is felt most strongly elsewhere, away from the states that have originally caused the problem. It's felt most strongly by vulnerable populations and cultures, predominantly in the developing world. We have noticed how a rise in sea levels has drowned and with time will drown large tracts of land, resources and entire islands. This will cause an increase in scarcity of food, water, healthcare facilities and housing, and will also have a monumental impact on diseases, plagues, epidemics and poverty. We also know that climate change will lead to large-scale displacement of populations from their traditional habitats. This will have two consequences. First, that there will be large-scale migration of these populations to more habitable areas. And this migration will come with its own problems of social conflict and unrest. So how is it that the problem of climate change can be addressed now? We know that given the scale of the problem of global warming, the fact that it is caused in one area, but its impact is felt in other areas, and that different countries have contributed to it in very differing proportions. Climate change is a novel problem that can be solved only through collective action. Measures by individual states might be helpful, but to a very limited degree, and it can only be contained effectively if states act collectively on the problem. So what are the issues that we will discuss through the course of this presentation? We will investigate what direction the human rights paradigm can supply to the problem of climate change. There are several different rights currently existing in different human rights frameworks that are affected by the problem of climate change. For instance, first, the right to environment to begin with. Second, the right to development, since climate change is an activity that is inextricably linked to the economic activities of arising out of industrialization. Third is the right to healthcare, food, etc., etc. But fundamentally, it is a contest between the right to survival of populations, their right to their environment, and the right to development. Within this, we notice that there is a great divide between the global north or developed countries and the global south, which are the developing countries. And due to this divide, there is a huge debate on the framework of responsibility that can be used in order to pursue collective action to contain global warming. The first time that attention was radically drawn to the human rights dimensions of climate change was on account of the Inuit petition to the Inter-American Court of Human Rights as recently as 2005, when the Inuit population inhabiting Alaska petitioned the Inter-American Court of Human Rights against USA and Canada. The tribes in Alaska were moved by the impact global warming and climate change was having on their immediate environment. Given the specific nature of the geography of Alaska and that it is frozen entirely through most parts of the year. Sustenance of populations and tribes in Alaska is related very closely to their environment in itself. The fact that global warming and climate change was changing the weather patterns and the climate in Alaska had a significant impact on the survival of the Alaskan tribes and their ways of living. They argued that the failure of their governments to act to contain climate change violated their human rights to life, health, property, subsistence, and culture. This was the first time that climate change was translated through the lens of human rights. The petition was eventually rejected before the Inter-American Court of Human Rights for failing to show a violation of human rights that were protected under the American Declaration. However, this was nevertheless a significant piece on advocacy on climate change and human rights. It brought to light first that climate change has a tangible, debilitating impact on human populations, and second, that the problem is not contained by national borders, since the people most impacted by it are vulnerable groups who have contributed little to the problem. The second time there was any international discussion on climate change was through the Male Declaration of 2007. Here, a group of small island developing states congregated in Male in the Maldives to bring attention to the problem of climate change. Now, these small island developing states, or SIDs, are most at threat from climate change, since the rising sea levels place at peril the existence of the country in itself, given that the islands are at a great threat of submergence. They discussed how these SIDs were the SIDs discussed how they were the victims of climate change without having caused it in the first place. But the Male Declaration on its whole was ambivalent about its relationship between climate change and human rights. It merely sought to draw the attention of the overall worldwide community on the problem of climate change, most notably the actors that were most responsible for it. This act of bringing attention to the problem was important for several reasons. First, scientists, NGOs and lobbies had for a long time been warning countries against the perils of climate change and rapid industrialization. Most developed countries, USA notably, nevertheless continued with its policy of business as usual, translating to climate change is not really a problem and that we can continue with our economic policies as before. They were continually undermining the threat that global warming posed to humans and to the environment, and continued to contribute to the problem further. The consequence of the Inuit petition and Male Declaration were successful, in that they sparked off international debate on climate change and human rights. The United Nations Framework for Combating Climate Change, or the UNFCCC, became activated and animated over the problem of climate change after the Male Declaration. The Human Rights Commission took notice of the problem of climate change and deliberated upon it and passed resolutions. And the official High Commissioner for the Office of Human Rights also took notice of the problem of climate change. But at that stage, did not extend so far as casting climate change as a human rights problem or casting the right to environment necessarily as a human right, but only stated that global warming impacts human rights of life, adequate food, water, health, housing, and self-determination. But throughout these deliberations, there remained a massive divide between the global north and the global south. The global north has been continually resisting efforts to couch climate change through a human rights paradigm. We discussed the several objections that the global north has raised to climate change as a human rights problem in international deliberations with international bodies. They claim first that the human rights most impacted by climate change are already the subject of the international human rights framework. The only problem is that they lack effective enforcement mechanisms. In that case, viewing climate change through the paradigm of human rights adds nothing to the existing framework of protections. Secondly, developed countries such as Canada and Germany argue that human rights obligations are owed by states to their national populations. This makes climate change a matter of domestic policy, and therefore no international framework of responsibility can be evolved, especially not within the human rights paradigm. Third, human rights obligations will further cast a heavy burden upon governments of developing countries, which are already the most hurt by global warming. They are under the greatest strain of inadequacy of resources, and they are the ones who would be for whom it will be the most difficult to divert resources to adapt to climate change. Fourth, the meat of the problem of climate change lies in environmental catastrophes and disasters, such as hurricanes and droughts, which we have seen in plenty over the past few years the world over, including in USA and India. We noticed how specifically virulent hurricanes managed to disrupt entire cities and displace populations to a very large extent. Now, as situations of emergency, these anyway empower states to suspend their human rights and fundamental rights in the interest of expediency. Therefore, at times when human rights will be most necessary, they will be ineffective. Fifth, developed states also claim that in securing the human rights of populations across their national boundaries by curbing industrial activities, states would be curbing the enjoyment of the human rights of property and development to their own populations. Sixth, developed states also claim that it is difficult to ascertain with certainty what the violations of human rights are in climate change, who the rights holders are, and who the duty bearers are. This is because human rights tend to be individual-centric and based on concrete instances of violations that need to be redressed, whereas climate change relates to generic impacts without a clear idea of the entity that is wronged. Secondly, the concern of human rights is the concern of present violations. With environmental degradation, the violations will in all probability occur in the future to future citizens. Seventh objection that the global north raises is that human rights supply a non-negotiable absolute norm in a process which is inherently reliant on careful negotiations between states to solve a global problem, and therefore actually undermines the solution. But the case that advocates a human rights paradigm for climate change is equally compelling. This is because human rights provide a minimum benchmark for action. They are only a moral threshold which states need to account for in their negotiations. And that is because existing vulnerable groups, according to poverty levels, gender, age, geographic location, disability, indigenous or minority status, are in fact the most strongly impacted by the problem of climate change. Through a human rights paradigm, the focus can be brought back to the existing vulnerabilities of populations that are most strongly impacted, and negotiations can therefore target their inclusion. Having a human rights-based approach to climate change therefore emphasizes non-discrimination, participation, and assumes lexical priority in negotiations. Within this atmosphere, it is necessary to change the orientation of the negotiations themselves. They are currently based on self-interested goal-seeking of individual nation-states, and not on the needs of the individual and the community, which must be accounted for. Human rights within climate change will ensure the accountability of states to three different entities. First, to other states, since the problem is a global problem requiring collective action. Second, to their own citizens by ensuring non-discrimination. And third, to the citizens of other states who are in fact the most vulnerable. We also know that human rights obligations need not be territorially circumscribed. We have discussed earlier the yardstick of human rights obligations as contained in international human rights instruments. For instance, Article 2, subparagraph 1 of the ICCPR operates on the notion of what is known as the effective control test, which means that if the violations are effectively in control of one entity, then that entity can be held accountable and responsible for it. When placed within the problem of climate change, we know that the actions, that the rapid industrial growth of in the developed world has a direct impact on the right to self-determination of remote populations to decide autonomously how to use their natural resources. Similarly, Article 2, Paragraph 1 of the ICESCR mandates that human rights must be secured individually and through international assistance and cooperation. Therefore, the ICESCR from the beginning envisions extraterritorial application of its mandate. There is yet a further nuance to this setup. Even if human rights obligations are viewed as territorially circumscribed, that does not extend across the board. While it may be true that positive obligations of securing human rights may be circumscribed by territory, the negative obligation to refrain from violating human rights definitely extends extraterritorially. Lastly, the human rights paradigm on climate change need not necessarily operate on a framework of individual liability, but instead on a framework of relative liability. Why this is relevant is because we know through in-depth research and statistics that the problem of global warming is in fact caused by a handful of states. 2/3 of the global emissions that cause global warming are caused by only 7 states. And therefore, in a paradigm that views liability relatively instead of absolutely, it will be possible to apportion differing levels of liability upon these 7 states that are the major contributors of climate change. Further, the OHCHR does not require existing violations to affix responsibility, but only violations that are imminent. Which brings us to the question of what is the regime of liability that the international climate change problem should adopt. While formulating an appropriate regime of liability, there are 5 claims of justice that need to be accounted for. First is the claim to corrective justice, where the actions of one group have harmed a different group. This notion of corrective justice is akin to tortious remedies, where the solution lies in seizing the acts that caused the injury in the first place, and secondly, by paying damages for the injury that has been caused. This is reflected in the current paradigm of climate change policy through the policy of adaptation, wherein the developed states are under an obligation to develop mechanisms to cope with environmental changes. The second claim is the claim to substantive justice, where there is a disparity between the states that have benefited and growth with the aid of economic industrialization and those that have not. These states claim that that developing countries have a legitimate right to development, which has been denied to them so far. So the solution within the current climate change policy framework lies in the policy of technology transfers, where the developed world is under an obligation to make greener technologies accessible to the developing world for growth. The third is the claim to distributive justice and procedural justice, which is formulated in terms of the polluter pays principle, by which the endeavor is to equitably distribute the costs of avoiding further preventable anthropogenic warming and of coping with the social damage that cannot be avoided. In the policy framework, this translates to fairly rationing quotas for emissions in the interim period. This claim is also interested in devising a process that can make bargaining in negotiations a fairer process. The fourth claim to justice is the claim towards formal justice, where countries that have so far relied on an industrialized mode of economic development have a legitimate cannot suddenly switch to a mode of development that changes their mode of production entirely. So there is a legitimate expectation on behalf of these countries or of prior users to a carbon-intensive economy. The sudden switch to an alternative mode of production will lead to massive loss of livelihood within that state. And therefore, the Kyoto Protocol has evolved, therefore the model adopted by the Kyoto Protocol in terms of its cap and trade emissions, by which emission rights are granted on the basis of prior use, and states internally can trade these emission rights as well. Lastly is the claim to intergenerational equity, which we know commonly as the claim to sustainable development, which means that development must now be undertaken in a manner that serves the needs of the present generation without compromising on the needs of the future generations. Given these differing claims of justice that are necessary to be accounted for in a climate change framework, the UNFCCC makes reference to three frameworks of responsibility. The first, through the lens of equity. The second, through the lens of common but differentiated responsibilities. And the third, through capabilities. These three claims are in recognition of the fact that, first, that most of the wrongs of climate change have historically been caused by the developed world, that different countries have differing capabilities in addressing the problem of climate change, that the developed world has more resources and greater technology to address the problem of climate change than the developing world. Third, it takes into account the developmental needs of the South as well, which has not so far prospered on account of an industrialization-intensive economy. And fourth, this takes into account the differing impact that climate change has on different populations across the world. While negotiations on curbing climate change and global warming were ongoing, there were several principles on the basis of which states were deliberating on apportioning responsibility and liability. Based on needs, capabilities, based on prior entitlements, based on just deserts, based on the greatest good of the greatest number, or based on formal equality. Given the multiplicity of principles on the basis of which the framework could be developed, states and scholars have agreed that these negotiations must largely be guided by an interest in equity. Now, equity is a rule that lacks any substantive content, but is more of a procedural rule that guides negotiations. And it was evolved to address the conflicting principles based on which the negotiations were ongoing. Most notably, however, is the principle of common but differentiated responsibilities. This was first discussed and mentioned in the Stockholm Declaration of 1972, later reiterated in the Rio Declaration of 1992, and finally also again emphasized during the World Summit on Sustainable Development in 2002. According to common but differentiated responsibilities, the responsibility of countries to curb climate change is commensurate with the responsibility in causing it in the first place. So, as we have discussed earlier, we know that 2/3 of the global emissions have been caused by all of 7 countries, whereas the impact has been felt by all 200 countries in the world currently. Apportioning liability equally upon all of these 200 countries would be grossly discriminatory and unjust. Common but differentiated responsibility seeks to attach responsibility upon those 7 countries that have historically contributed to the problem, and countries like India and China who are contributing the most to the problem in the current times. Secondly, the responsibility is also commensurate with their capability to curb the emissions. This is reflected in the policy of mitigation in climate change, where the global north is to assist the global south in mitigating and adapting to the harms of climate change. What this framework of common but differentiated responsibilities accounts for are: first, historical emissions; second, projected future emissions. Since there is a distinction that Posner draws between the stock and flow of emissions within the atmosphere within the current atmosphere. Since there is a distinction that Posner draws between the stock and flow of emissions. The stock of emissions are the emissions that are currently in the atmosphere of the Earth on account of emissions over the past 1 century, which are largely constant and dense. But the flow of emissions is the variable emissions that the current use of industrialized technology is causing. Posner says that in order to correctly apportion responsibility, the stock and flow must both be accounted for, and therefore the projected future emissions must also be a factor in climate change negotiations. This brings the responsibility of China and India squarely into the picture, whose emissions do not go as far back historically as the developed world, but who are currently one of the leading but whose emissions are growing at a rate much faster than the other developing countries. China, however, seeks to throw a further factor into determining emission standards and liabilities, which is the per capita consumption. Given that China's population is the largest in the world, they say it is also expected, in order to serve the development needs of all of its population, that its emissions will be proportionately larger. In the interest of individual well-being, therefore, negotiations must account for the per capita emissions of states as well, in which case it would be unfair to apportion an equal number of carbon credits between China and UK, whose population is much less, but whose per capita emissions far outstrip those of China's. So what are the strategies that have been evolved under CBD? The first is the strategy of the carbon tax. The carbon tax is imagined to be uniform for all countries, but there is a massive debate on what the rate of the optimal tax should be. And secondly, within economists, there is a debate on what rate of optimal tax will deter further emissions. And secondly, there is a massive divide between the burden and the responsibilities that countries themselves are willing to undertake in terms of tax payments. The second strategy is the strategy of cap and trade mentioned in the Kyoto Protocol, which places a ceiling on the emissions of different states during different phases. And within those different phases, it also empowers states to trade their carbon credits. The third model is the model of the side payments as mentioned in the Montreal Protocol, by which to incentivize net losers from a paradigm of climate change accountability, to incentivize them to participate in the negotiations and participate in the process themselves. The Montreal Protocol evolved the mechanism of side payments, where they will be paid on the side to curb their emissions. Failing this incentive, large emitters such as Russia would have been unwilling to participate in the collective action itself, defeating substantially the purpose that it was meant for. So in summary, we know that there has been a grave disagreement between the global north and the global south on what the responsibility regime should be to curb climate change, even as we know that the problem of climate change can be solved only through collective action, and that the impact of climate change is felt most by populations that have not caused it in the first place. Thank you.